Everybody's here, so Ms. Spears, you're up.
Thank you, Your Honor. May it please the court, counsel, my name is Abby Spears and I represent Dr. Alan Brockhurst. I would like to reserve 5 minutes for rebuttal, please.
You got it.
Thank you. Your Honors, we're here today before you for review of the non-final order of the trial court, which granted leave to plead punitive damages on a claim for conversion. Procedurally, we actually have two non-final orders, which collectively ruled on exceptions and cross-exceptions to the magistrate's recommended order, the result of which gave Dr. Alawi as a derivative party on behalf of the entity we commonly refer to as ISA or Imminent Surgical Associates, the right to add ISA as a party in the action while simultaneously granting that party the right to bring a claim for relief for punitive damages on the claim for conversion. Punitive damages would not have otherwise been recoverable or permissible under the law against the derivative party. Excuse me, on behalf of the derivative
Can I ask
party.
you one question? One
Sure.
question. You filed a motion to abate on the basis that you want the Supreme Court to decide the conflict among the DCAs between the 4th, the 5th, and the 2nd, correct?
Additionally, we did, yes, Your Honor.
And that was denied, correct?
Yes.
And your argument now is it doesn't matter what they decide, you win either way?
Correct.
Permissive or Doherty? Explain that.
Correct. Sorry, Your Honor, correct. We have argued that under either standard, we would prevail. We have in our initial brief, I believe in our reply, included additional requests for this court to sort of stay this proceeding or abate the ruling and allow the parties to rebrief the action if the Supreme Court decision in Perlmutter is decided in a way that changes the application or the way this court is to apply the standard under Section 768.72. But our argument here today, in addition to that, is that even under the standard as this court has been applying in Dieterle and other cases, we prevail in having this action remanded and having this trial court order rescinded. So on that basis, Your Honor, we contend that there's a heightened burden to be applied here, even if you're not applying the Perlmutter standard and you're going under Dieterle and the other decisions of the second DCA. Because as this court has stated, punitive damages are reserved for anomalously transgressive conduct that is outrageous in character and extreme in degree. And this court made that statement in the CCP Harbor Island case and cited it again in December of this past year in the Publix Supermarkets case. Section 768.72, I'm sorry, Judge, I think the feedback's coming through your box. Did you have a question? No, okay, sorry. So in 768.72, there's punitive damages claims are limited to instances where there's a reasonable showing by evidence in the record or proffered by the claimant that the defendant was personally guilty of intentional.
Define reasonable evidence in the record. Is that just you say what you say? That's reasonable? That's evidence in the record? Or is there more to it?
I believe there's more to it, Your Honor. I believe the jurisprudence says you're not to strictly do an evidentiary hearing and weigh the evidence as you would do a trial. I believe the second DCA has said you don't necessarily need to get to the heightened level of clear and convincing under subsection 2 of the statute, but you certainly must take into consideration evidence cited by the non-movement, which the court must then consider to the effect it countervails or conflicts or completes the record that is cited by the movement. And that is what we have done here and what we argued to the trial court below. The magistrate in his ruling, recommended ruling, made clear that he did not consider anything cited by the non-movement, which we argue is improper. He made clear in his record at the hearing that he was limiting his review solely to the proffer and that the proffer, in his opinion, was sufficient to meet the standard. We argued with the exceptions and cross exceptions that the trial court must look at all evidence cited by both parties. And I believe the trial judge, ultimately the circuit judge, agreed and indicated summarily that he had reviewed all evidence and in doing so then adopted the recommended order without further specifying what evidence from the non-movement he had reviewed. But it's our position.
It appears the trial court did review it all. We got to take his word for it. This seems to be a low standard for a reasonable basis. The legislature never defined it, but we've got to stick with it. Subsection 2 is the burden of proof for a trier of fact. The trial court is never a trier of fact. You want to see the difference between punitive damages statutes? Just look at Florida statutes 400.0237. Legislature clearly said the trial court has to determined that the claimant can prove beyond clear and convincing evidence. So the legislature knows how to write it. So here, upon our review, we've just got to look and see that the magistrate and the trial court do what they were supposed to do. So they had a proffer. And I think you must agree that Dr. Alawi had the magic words in his complaint, wrongfully, intentionally, with knowledge to injure and all this other kind of stuff. But also that your client swore under oath in September of 21 against another shareholder. He took a legal position, a very concrete legal position, that Jake's forfeited all of his rights to share any interest in the shares. And then he affirmed that. He also affirmed that he should get, consent by all the shareholders for over $15,000 withdrawal. So despite those legal positions that he took in 21, he then takes a different position here. And I think the court considered that. What I see in your argument, and you can help me clear up any misconceptions, is the proffer that Dr. Brockhurst made was a defense, really, going to the weight of the evidence, as opposed to this isn't a reasonable basis for the entitlement of punies. He basically said, no, I didn't. No, I didn't. State of mind. I didn't mean to do this. I didn't mean to do that. But the court noted that there's filings that contradict what he's saying. So help me out.
Yes, Your Honor. So I definitely take the trial court judge at his word that he reviewed all of the evidence, but that is not specifically cited with respect to the ruling that was entered. Again, it was just a statement that it had been reviewed in that respect. But our contention is that the de novo review includes the proffer and the 95 itemized material facts that were listed in our response in opposition to the motion for punitive damages, which are not strictly a defense, but again, provide that completeness or clarification. The move-ins here made selective arguments and excerpts of evidence that avoided information that would contradict what they were saying. They were very artful in their presentation, but that is why the evidence here cannot be exclusively viewed through the proffer of the movement and must consider evidence in the record cited by the non-movement. That is part of the jurisprudence.
Wait. Isn't part of the jurisprudence also that the scope of review is adjacent to, if not the same as, the facts are accepted as true, and inference is drawn favorably to in this case, the movement. And what you're talking about is, the weight of your client's evidence against the evidence that the claimant relied on. And I think we're kind of going in circles, but that in the context of the applicable standard for the trial judge to apply, where I'm having trouble with the part about, but he should have looked at the negative evidence better. He should have believed it more.
Thank you, Your Honor. And I think your audio dropped out a bit for me, but I think I understood what you said with respect to the method of review. And yes, there's some deference to be given. Certainly, the evidence is to be viewed in the light most favorable to the movement, but not to the exclusion of consideration of that evidence. So there's some shocking examples, I think, in our briefs that lay this out. So, for example, bare assertions cannot be considered on their face. And I think the White versus Boyer case from the second DCA in 2021 solidifies that point. We can't just look at their bare allegations as true without considering or looking at the evidence cited by the non-movement to the extent that is implicated. So by example, you mentioned the issue, one of the issues in this case was whether the money that Dr. Brockhurst withdrew, which is of course the subject of the conversion claim here, put the entity in some type of peril. And the magistrate indicated that Dr. Brockhurst knew or should have known that this money would put the entity in peril. And that was based on one self-serving statement in a proposed second amended complaint by Dr. Alawi that was filed in connection with the motion for leave to amend that said that due to this money being taken, had he made these other distributions, that there would not have been sufficient funds. But he didn't cite anything in support other than his own testimony. The Evidence, by contrast, when you look at the actual financials of the entity, which is what Dr. Brockhurst proffered, was not his opinion, it was the entity financials to say that's simply not true. And you cannot ignore the actual evidence in the record, which shows the financial statements of the business, which showed a large sum of money in the account at the end of the year. The magistrate also looked at, again, the harm to the business, but the actual harm that Dr. Alawi was arguing was harm to himself as a shareholder, which is not actionable. He claimed he couldn't pay his personal taxes out of the bank account for the entity, but there's no such obligation cited or in existence. He didn't have to pay his personal shareholder expenses out of the business, nor was he required to. And there was sufficient funds in the account. So the evidence shows, while Dr. Alawi is seeking punitive damages for Dr. Brockhurst's $415,000 approximate dollar withdrawal. The actual number was $415,599 and 55 cents. He himself withdrew over $525,000 that same month unilaterally without Dr. Brockhurst's approval. So if you're looking at something in isolation in a vacuum, and I think the analogy we use in our brief is if you're arguing someone was expeding excessively, because they were going 70 miles per hour, but you exclude the non-movement from arguing that the speed limit in that vicinity was 70 miles per hour, you're not allowing the finder of fact to consider all of the relevant evidence. And that is essentially what the movements have argued here and continue to argue.
Isn't that why we have two parts to 76872, where you've got a pretty low bar for a reasonable showing? And that's what the trial judge is charged with assessing. And then the claimant has to prove by clear and convincing the standard of intentional misconduct or gross negligence. And what you're talking about sounds to me a lot like the quantum of proof that's going to have to be marshaled under part 2, not part 1.
I understand, Your Honor. I don't know that that's what we're arguing. We're not arguing for the clear and convincing standard, but the intentional misconduct, the gross negligence, what rises to that level, what type of evidence rises to that level must be considered. And what we're looking at here is whether or not he believed he was entitled to take certain amount of money, and whether that mere taking of money was somehow so egregious and recklessly in disregard of the rights of the entity that supports a punitive damages amendment, which is a very high burden, in my opinion, because it creates a substantive right for discovery.
Wait. Is it the entity, or is it because the conversion claim is not brought as a derivative claim, or to the extent it is, that's not where punitive damages are implicated. He's got an individual claim for conversion. And I have this question for your opponent in a slightly different manner, which is, if the damage is solely that of the entity, how are we even here on this? Because we know that punitives aren't awardable in a derivative. If the damage is in the more conventional conversion, you took my stuff, you knew it was mine, and you didn't give it back, even though you knew, and I told you, and I wanted it back. That's the tort of conversion. I'm not sure how it matters that much, other than the money's gone and it was mine, or at least I had a claim to it. But the issue of whether the entity was damaged to me seems like a red herring. Bottom line, and this is the question I think you're confronted with here, is there is a difference, at least in this district, between looking at whether the proffer makes a reasonable showing and considering the evidence in the record, versus whether that evidence rises to the level required by 2, which is what the jury is here for. And, we don't know what the answer to that's going to be. But I think your argument would do a lot better in the Perlmutter realm, but that's not what we have right now.
Understood, Your Honor. And I just want to go back and correct maybe some misapprehension or misconception of the issues here. The procedural posture is that ultimately, after leave to amend was granted, that the plaintiffs, meaning ISA as an independent party, as well as ISA derivatively through Dr. Alawi, have both asserted a claim for conversion. The motion that was ultimately granted and the order entered at the trial court level gave ISA directly the right to plead conversion against Dr. Brockhurst. That is what's pending. And that is not a derivative, but a direct claim for conversion with punitive damages pending. That's what is at issue. So we are talking about harm to the business. It must be harm to the business for it to withstand punitive damages here. So that's why when Dr. Alawi argues about his personal harm, his inability to pay himself his taxes that he would otherwise like to flow through the company but not required to, that's the red herring from Dr. Al-Rawi's perspective, because the harm here must be harm to ISA because it is their direct claim for conversion and direct claim for punitive damages. But we did note in our brief, which might have led to some of the confusion, that when they ultimately did file their third amended complaint following leave of court, they did assert punitives on behalf of both. So it led to some confusion there.
Ms. Spears, you're at your 5 minutes. You want to keep going or you want to save it?
I will just say that on the grounds that we believe that the standard has not been met with respect to the reasonable basis of the reasonable showing to that, anomalously transgressive conduct here, we would ask the court to reverse the trial court's ruling, please.
All right, you got 4.5 left.
Thank
Mr.
you.
Hutton, you got 20.
Thank you, Your Honor. May it please the court. My name's Steve Hutton with Hutton, Domingo, and Stahl in Sarasota. And we represent the appellees, Dr. Al-Rawi derivatively on behalf of ISA and ISA. Counsel has tried hard both below and in this court to dance around the issue of, aren't you really asking the magistrate, the trial judge, and now this court to weigh the counterproffer? And of course, that's exactly what this is. I mean, why else bring up all this information if that's what you, or is not what you want the court to do? And our proffer is fairly simple and fairly tightly contained. There's a summary judgment order in August of 2023, which is in the appendix. There was a verified First Amendment complaint, not merely a complaint with allegations, but verified by Dr. Al-Rawi, and a verified Second Amendment complaint. And much of what we argue in support of punitive damages has been established as a factual matter in this case by Judge Carroll's order of August of 2023. Now, the counter proffer, as I will call it, because that's exactly what it is, can fit into two general categories. Number one, Dr. Brockhurst believes he was entitled to take the money in December of 2022. And he justifies that alternatively. First of all, said it was because he thought Dr. Al-Rawi had taken a bonus, and in fact he had. But the irony of saying Dr. Al-Rawi taking a bonus justifies me taking money is Dr. Brockhurst had not and could not work for ISA since June 18th through the end of the year. He had been forced to take a voluntary leave of absence and then was forced to resign. Hadn't generated any money because he couldn't work for the hospital.
Mr. Hutton.
Yes.
Mr. Hutton. We've read the magistrate's findings, and of course, Judge Carroll adopted those. And I think the magistrate made, a pretty detailed explanation of what he was finding as the basis, excuse me, to satisfy subsection 1. But the question I have that I want to ask you is this Perlmutter issue. Our court doesn't apply the Perlmutter standard. We're in conflict with that. But this case presumably would be a pipeline case, depending on how our resolution would go, or maybe either way. But my question to you is, if we apply the Perlmutter standard here, what happens? Because now, under Perlmutter, we would be looking at the counterproffer to assess the propriety of, or the sufficiency of the overall body of evidence to support clear and convincing. So help me out with that.
Well, first of all,
we have our own precedent, and it's different than Perlmutter.
Correct.
Perlmutter is pending in the Florida Supreme Court. So we could get an answer on that Thursday. And how does that change your argument, or does it?
well, I don't think it does for two reasons. Number one, the Perlmutter issue was not preserved for appeal. It was never argued below that Dieterle, although the law of the second DCA, we believe was incorrectly decided, and Judge, you ought to look at Perlmutter and apply that standard again. Even though you know that's going to be dead on arrival with Judge Carroll, That's what you have to do to preserve the issue for this court. So point one, it's not preserved. Point two, if that heightened standard comes out, I guess the question becomes, is it going to be retroactive? And if so, retroactive to when? Because there's been a lot of punitive damages cases decided over the years, not on that standard. But, could you, in looking at the proffer and counter proffer, again, viewing the evidence in light most favorable to ISA, come to the conclusion that there is enough evidence there for clear and convincing proof of punitive damages? And I think the answer is yes, if you give the benefit of the doubt to the claimant, as I think you have to do even under Perlmutter. Because number one, you've got somebody who took it upon himself to take money out of an account that the agreement had always been nobody takes more than $15,000. And frankly, Dr. Brockhurst never took money out of the account. At the time he did it, he knew he was being sued to have his shares forfeited and his status as shareholder forfeited. He knew he had signed under oath in another case an affidavit that said exactly that this is the intent of our bylaws, that if you can't work and generate money for the company, you forfeit your shares and you lose everything. So he can talk all day long about, I believed, but I think a jury is entitled to find that his actions and his prior statements belie that belief.
Mr. Hutton, I have a question.
Sure.
So Dr. Brockhurst made this withdrawal while your client filed a deck action and pled that he was unsure of the legal status of Brockhurst as a shareholder, and he needed court intervention. So Brockhurst made the withdrawal while that was pending. Had not been heard, had not been decided. It still isn't final. So you really don't have him violating anything because your client took it upon himself to tell the court, hey, I think there's a bona fide dispute. So it seems to me that any punitive damages would be for his wrongful retention and rejection of returning it. Wouldn't you agree?
Well, I always thought that was the better argument. The magistrate did not agree, but certainly by August of 23, Dr. Brockhurst knew for a certainty, at least in this case, unless and until the second DCA might consider it and reverse it, that he was not a shareholder and he wasn't entitled to the money and chose not to return the money. Now, the magistrate was skeptical of that argument because he said, well, there's nothing in the order that requires him to return the money. And this is probably my fault. I probably didn't make my point.
I thought that did you argue below? I
Yes.
thought maybe you made the argument that you'd ask for it back. And
yes.
And then you'd ask for it back after this.
Right.
So I'm troubled by this case, and I'll tell you why. You cited, I don't know how to pronounce it, Kymar, and Foley. Those are pre-statute cases. They're instructive, but they're pre-statute cases whereby those courts didn't have to follow what we have to follow now. And I don't see any cases on point where we have two partners of a private entity, one of which is out for whatever reason, stealing, whatever. Let's just say stealing. And you've got to count for punitive damages where a trial court has granted the motion. And so it makes me look at the purpose and objective of punitive damages where our courts is replete with explanations and articulations of egregious, sufficiently reprehensible to rise to the level of truly culpable behavior deserving punishment, conduct that calls for punishment of the offender, deterrence of others that might otherwise act similarly, the conduct that calls for punishment as deterrence rather than compensation, extraordinary relief, not mere compensation, but punishment, conduct that a reasonable and ordinary person can describe as outrageous. What's the objective and purpose of punitive damages in this case? These are two private partners, obviously liked each other for a while. Now they don't. But what message are we sending anybody else? There's no message to send anybody but Brockhurst. So how does this fit within that?
Well, you certainly, there's nothing wrong with sending a message to the wrongdoer, but the bigger message that gets sent is consider if conversion short of I've got a gun and rob somebody, if anything short of that does not give rise to punitive damages, then you could take money from a company with impunity in the sense that the worst case scenario is you have to give it back with some interest. I mean, it's deterrence to future conduct where people undertake, and I'll give you the benefit of the doubt and call it self-help, but I mean, the easy answer for him, and he's done it now, is file a counterclaim and say, I'm owed that money. Why didn't you pay
Well,
me that
we
money?
don't know about that, so.
Okay.
But we've got a case where at least you can see that his accountant indicates that he's entitled to $9,800, and that's those your client, Dr. Alawi, say, okay, he's entitled to something, but it sure isn't $415,000. So wait a second. So he took money, he took more than he was entitled to. So why isn't this just a dispute between two partners over how much he's entitled to, rather than some intentional misconduct for which, we're going to destroy his life by just simply sending a message to one doctor from another? Hey, don't steal again?
Well, it's not sending a message just to him, but granted, it will send a message to him. But, my law firm, for example, one of my partners just decides to take money and go. I mean, if the only punishment for that is you might have to give it back with interest, I mean, that's some punishment, but that's not much by way of deterrent. And I mean, in a conversion context, again, short of somebody robbing a bank with a gun, what would be an egregious circumstance? And I think this is it, where you have somebody that should know for a matter of fact in December, but certainly knows for a matter of fact in August, he's not a shareholder, and his claim for the money that he took was my share of the distributions. Well, you're not a shareholder, you don't get distributions.
Was anyone ever charged with a crime?
We did not bring any criminal charges.
You didn't file them, or they didn't?
We did, was not disclosed to the
Chosen
state attorney.
to file for civil conversion of the theft and treble damages, correct?
Correct.
Okay, I got you.
And again, a different standard there, hence our going down parallel paths. And I recognize we would not be in a position if we won both to recover both, but it's certainly, in my opinion, a different standard for punitive damages than it is for civil theft. But let me go back to this whole idea of damage to the entity itself. The damage to the entity, and obviously we put into the record that there was damage above and beyond just the theft of the $400,000. But that's damage sufficient in and of itself to cause damage to the entity. They have $415,000 less. Now, the ramifications of that, we say were pretty bad. Counsel belittles Dr. Alawi's claim that he was entitled to get his shareholder quarterly payments paid by the entity. Well, that historically is what they did. It's not like this is a brand new thing. And she also then fails to recognize that because Dr. Brockhurst took it upon himself to declare a distribution for himself, there wasn't enough money left for Dr. Alawi to take a distribution at that time either. So again, he made the effort to minimize the damage the corporation otherwise would have sustained, but let's not minimize the fact that there's 415,000 missing. And if the law of this state is going to be, if you're wealthy enough or big enough, you can steal quite a bit of money, and as long as it doesn't put you on the verge of bankruptcy, that's not grounds for punitive damages. I think that's a problem, and I think that's a bad precedent.
I understand and appreciate your argument as to ISA. What is the damage to Alawi personally? I mean, does he have to personally fund the expenses and the operating costs now?
Yeah, and just to be clear, Alawi personally is not a party in this lawsuit. He's only derivatively on behalf of ISA, and then ISA as the main claimant.
Okay, so the damages is to the entity.
Yeah, and again, yeah, he did have to not take certain amounts of money he would otherwise be entitled to keep the entity from having year-end problems. Now, was it, long-term fatal? no, that's not what caused the company to no longer be in existence, but it certainly was short-term painful. Unless the panel has any other questions of me, I think I will just close by saying this is clearly a situation where counsel wanted the magistrate, the trial court, and now this court to weigh the evidence and pick a winner at this time. I mean, that's just not appropriate under any standard, including Perlmutter. If you look at the evidence in the light most favorable to us, and again, most of our evidence is undisputed because it is contained within Judge Carroll's partial summary judgment order. If you look at that evidence in the light most favorable to us, under any standard, I think this is a case that there should be punitive damages, at least the opportunity to do so. And we request that the court affirm Judge Carroll's order.
All right, thank you, Ms. Dutton.
Thank
Ms.
you.
Spears, you have 4.5 minutes left.
Thank you, Your Honor. Contrary to what Mr. Hutton said, there's no evidence in the record that ISA was not able to meet its end-of-year financials or any risk of not meeting its end-of-year financial obligations. What is in the record and what we cited, and we don't think can or should be ignored, whether you're weighing the evidence or not. It is contradictory to what Dr. Alawi has argued. He himself took $525,000 in an unprecedented payment to himself that month. So he has attempted to argue that the entity did not have money or was at peril or some loss from this money being removed. But he at the same time was taking unprecedentedly large transfers out of the accounts. And we put that in our opposition and put that before the court as record evidence. We have the bank statements, we have the financials, we've showed the unprecedentedly large cash transactions he was making during that time period without Dr. Brockhurst's approval. And going back earlier to Judge Sleet's question about the prior testimony in the Dr. Jakes litigation, we also did provide information evidence about that from the record in opposition to the magistrate's comments with respect to Dr. Brockhurst, knowing he was quote unquote like Dr. Jakes in this scenario. There are stark differences between those two. Dr. Brockhurst was a disputed shareholder, as the court has recognized. There was litigation ongoing. And in the Jakes litigation, Dr. Jakes continued to receive payments from the shareholders while that dispute was pending. And it wasn't until that matter was settled outside of court with no judicial determination being made that Dr. Jakes' shares were redeemed. So Dr. Brockhurst has argued through the record evidence that he believed he was a shareholder. He withdrew money from a distribution he otherwise believed he was entitled to. He did have affirmative defenses pending with respect to set off and arguments related to entitlement to money that he believes he received. And all of that remains pending and within dispute of the parties. He has acted in accordance with what he believed was his shareholder rights, and there's been no determination at that time in December of 2022 with respect to those rights. And to address the summary judgment that was ultimately entered in August of 23, as we have argued, the court specifically stopped short of making any final determination with respect to return of any monies that might have been received. All the determination was made in August of 2023 was that Dr. Brockhurst was no longer qualified to be a shareholder as of that time. There was no calculation as to monies owed between the parties, and that remains in dispute between the parties to this day and will be subject to potential trial going forward in this matter. So we believe, Your Honors, that based on the standard to be applied by the second DCA, not even going to Perlmutter, but going to Dieterle, going to the Publix supermarket cases and the other cases, that the facts here are not as anomalously egregious as one must find when you have two trauma surgeons who are 50% shareholders having a dispute over cash that has been withdrawn, frankly, by both parties, and that the court, looking at this evidence de novo, should find that it doesn't rise to the level heightened and necessary for that egregious conduct and for that amendment. So we would ask the court to remand and reverse this decision so the parties may proceed in the underlying proceeding. And if the court doesn't have any questions, we will rest with that.
All right, thank you, Ms. Spears. That's it. Let's move on to the next case. We'll take it under advisement.